All right, good evening. It's 7 o'clock. We'll wait until the meeting started. First off the bat, we want to, of course, consider approval of the minutes of the Board of Adjustment meeting on January 7, 2019. We'll have a chance to look at those minutes.
Make a motion to approve those minutes.
I'll second.
The motion being made and seconded to have a vote. These working? I guess we are. They're blinking. It's like a miracle, guys. That's the only good thing parts, by the way. Perfect, they pass. All right, second, under 2B, conduct a public hearing and take action on a structure deemed a dangerous building and a public nuisance. The subject property is commonly known as the Cotton Gin Building located at 4005 Coyle Street, further described as a 0.411 plus or minus acre tract of land in the Thomas Payne Survey, abstract 1165, City of Rowlett, Dallas County, Texas. Here comes City.
Good evening, Chairman Board. I will just let you know this is a continuation from our meeting on January the 7th, where I provided some photo evidence and some different information regarding the building at 4005 Coyle, and some information on the 1997 Uniform Code for Dangerous Buildings. As your order indicated, you requested some witness statements from our fire marshal, which is present to make a statement, as well as an assessment of the building's structural integrity by a structural engineer, which we also have present with a presentation tonight. So unless you have some questions for me, I'm happy to call them forward.
Not at all. Thank you.
Excuse me, I know this is higher than usual, and I apologize, but Hazel Martin is present, and it's just too difficult to bring her inside, and I don't want to leave her in the car for too long. So if you don't mind, may I just say a few words?
Oh, you officially haven't opened the public meeting yet. So we haven't opened the public meeting yet. Or
Okay,
given a chance for that particular part of it either, so.
okay, again, I realize it's unusual, but she's almost 98 years old, and she's sitting outside in the car, and I just want her to stay safe. So I can't bring her in, you just make an exception this time, and I so appreciate it. I just have a couple things.
Would she have to come, are you going to speak on her behalf?
I am. I'm her granddaughter, Christine Martin. And so I just have a couple of things. Hopefully it won't take too much time at all, but I'm
Okay.
excited about being out there.
We'll take a brief shift right quick, so.
Okay,
All right,
I
please.
appreciate that.
Can you come in front of here, please?
Yes.
What's your name and address, please?
My name is Christine Martin. My address, and I'm sorry, this is a little emotional for me because our family's been going through a lot. 136 Landon Drive, Edmond, Oklahoma. And I drove down here tonight and I brought my grandmother in hopes that she could come in, but she's just not well enough. So I want to say, first of all, I'm very sorry that this has caused the conflict that it's caused. We've got some things going on in our family that have nothing to do with the city of Rowlett, and so we've had a difficult time getting the guardianship in order. So I want you to know that I know it's her intention, and I know it's her wish to work with you. I know that she told me 2 years ago she was ready to sell the property. So if you could give us a little bit more time, I went over the paperwork with her tonight. She feels like she's been blindsided because she does not live at the address 4210 Keel Drive any longer, so she's not gotten the notices. I think that we can work together and we can solve this problem for everybody if we just have a little bit more time. So I have a document, it's a letter of intent. My father is also out in the car with her, and he signed it for her because she's no longer able to sign a signature. But if you'd like this, I don't even have a copy. I didn't have time to make one, but because I just got here as fast as I could. We wanted to be out of time. So again, this family is not interested in causing conflict. We're not interested in causing the city a problem. We're not interested in delaying anything for you. We were very supportive of the development of Rowlett. My father met multiple times with David Berman and shared his support as far as what the plans for development for this particular property is. We have just had a lot of family conflict, unfortunately. But I can say that I believe at this point, the reason I came tonight is because I do believe that everybody's on board at this point with selling the property. So if you could just give us a little bit more time, I think we can come to a conclusion that hopefully will save everybody a lot of time and energy and money and conflict. And I appreciate you letting me know that.
Was your father the heir?
He's the sole heir. I have a copy of her will in the car also, like that. I brought a copy of the last appraisal that we had done. And the letter of intent does state the price, I believe, that was agreed upon maybe 2 years ago. However, I'm just trying to get us on some solid common ground. So we have the copy of the appraisal, we have a copy of her will that shows he's a sole beneficiary. And I think those are the documents that I have with me tonight.
So are you saying that you were prepared to sell the land? Is that what you're saying?
I'm saying that I believe that we are prepared to sell the land. I obviously cannot speak for everyone in the family, but I do believe we're finally on a similar page. I think there's been enough conflict that everybody has agreed that it's time to do something different. I will do everything in my power to help this go through. And I know that, like I said, I know what their intentions were, and unfortunately sometimes life throws curveballs, and we just weren't quite prepared for what kind of hit our family. So this has gotten stuck in the middle.
Did you get copies of that stuff?
Yeah, can I ask a couple of questions?
Of course.
You understand that we've been involved in the litigation, not just dealing with the property, but the litigation for years now. I think you and I might have met once before at the courthouse.
Yes.
During the one and only hearing that the court has ever had in.
I am so sorry, but I think that is the correct one. I need to run and just check to make sure they're okay out there.
I want to talk to you. I really,
Okay.
I do.
I do, and I do too, but obviously first priority has to be their safety, and it's too hard to get in here. Let me just make sure they're okay, because the alarm's going off,
Okay.
and that's a concern,
All right.
and I'll be right
Yeah,
back.
we'll proceed with the hearing, but we'll recess or.
All right, I appreciate that. And I will say, we have only had one appearance in the court because the families had some disagreement, so.
Well, I'm well
Yeah.
aware of the details.
Right.
All right.
Right.
Well, Chairman,
Okay, thank you. I apologize.
Okay, let's go ahead and just move forward very quickly, so with the presentation.
I'm going to introduce Jacob Weiss here with J.P. Morgan. Chase Farm. With Walter P. Moore.
Thank you. Good evening. I appreciate the opportunity to be here and give a quick presentation on some of our findings that we have. We visited the property this past Wednesday and conducted a visual assessment, have done some limited structural analysis on the select representative elements of the property. Go ahead and jump forward here, I think. Maybe. Maybe not. Okay, there we go. Apologies. Quick executive summary, we did a visual assessment and limited structural analysis of the property in accordance with the current City of Rowlett Building Code, which is the 2015 International Building Code, and compared the findings of that analysis to the definitions for dangerous building that are contained in the 1997 Uniform Code for the abatement of dangerous buildings, specifically Section 302 of that code. Some of our quick observations of buildings that we observed loose in large spatial panels, both in and around the building. Noted a number of columns that were missing flange bracing and a load-bearing wood frame partition wall inside the building supporting one of the mezzanines. The quick takeaway from this is that 3 of the criteria that the code for the abatement of dangerous buildings that define a dangerous building from a structural standpoint are present in the facility. And we'll talk a little bit here about our specific observations and findings of that analysis. Some quick background for everyone. Our scope, again, was a visual assessment. We didn't do exploratory openings. We're not doing any sort of testing out there. We did do some documentation for representative structural dimensions to enable us to do that analysis. And our criteria for this was, again, the 2015 building code, 2015 International Building Code, as well as the definitions contained in UBC 1997. I did want to note that our assessment is limited only to the structural components. We did not evaluate any electrical, mechanical, plumbing, anything like that in the building. Just to summarize the structure, we really have, from a structural standpoint, three different systems out there. The west portion of the building is a cantilever column system with purlins, which is the small roof framing, framing between the main roof frames and girts supporting the corrugated sheet metal. The middle portion of the structure is a cantilever column system, again with purlins and girts supporting the corrugated sheet metal. Purlins being the small roof, the small elements supporting the roof sheathing, the girts being the small elements supporting the wall sheathing. In the middle portion, we have a wood frame and steel frame mezzanine level present in this area. And then finally, in the east portion of the building, we have a portal frame construction with purlins and girts. This area also has a wood frame mezzanine level as well. Some quick observations as we went around the building. On the exterior of the building, things that I think are pertinent to our discussion here. Number one, we had a number of, the access into the building was not controlled. We were able to walk in, the back door of this facility is open. We noted some loose panels both on the interior and the exterior, so people are appear to be getting in and out of the building at this point. As we go to the front elevation, I want to just point out that we have a awning on the front part of the building. We'll talk about some of the specific observations that relate to that particular structure, but I just want to point out this is a little bit different from the rest of the building, and that it will be subjected to uplift flows from wind in the event of a high wind event. The west and east elevation is very similar to the other elevations of the building. The corrugated steel fascia on those buildings have some evidence that some openings have been closed up and repaired. On the interiors, at the west building interior, we noted nothing particularly striking about the structure in this area. We noted a lot of evidence that people have been inside this building over the course of time. But you can see that we've got some steel columns in here. We've got our roof, the roof purlins. We've got some evidence of old mezzanines in this area, but nothing that appeared to be very accessible. On the middle portion of the building, again, this is a high roof. We've got a column. Unfortunately, I don't think our mouse or our pointer is working. Oh, there it is. You can see, just a little bit of context here, this is one of our columns in the building that we're going to be talking about. This is another column. Things that we observed here is the absence of the flange bracing that you expect to see. Bracing this column at intermediate points for purposes of our analysis. This column is essentially standing unbraced over the height of that building. You can see the open web. I apologize. I'm not very good with the mouse tonight. You can see the open web steel joists that are present there. And you have, at least in this picture, you can see remnants of a mezzanine level. You can see the mezzanine level beyond this that's supported on this wood frame wall. And over here on the right-hand side, you can see that mezzanine, again, you see the mezzanine above, You have a steel channel support spanning underneath it, spanning across the width of the building. It's approximately about 24-foot span that it has there with 2x joists on the span between the channel supports. On the east building interior, again, we have, this is our portal frame structure. It's pinned at the bottom, but the most pertinent observations we have is that we have a mezzanine that is comprised of 2x8 spanning approximately 24 feet between the two walls of the structure in this area as well. We noted as we were walking around out there that the load-bearing wall here supports the mezzanine. You can see the steel channel that is anchored onto this wall, the joist framing into it. This wall is bowing out a plane inside the building, and so, you know, both from a gravity standpoint and a lateral standpoint, this wall doesn't appear to have capacity to carry the code prescribed loads. At the awnings, you have steel base plate connections down onto what appears to be some kind of a base support. We noted that not all the bolts are tight at this location. Some of the base plates are missing anchor bolts, and these connections would be considered to be inadequate to resist wind uplift forces. And finally, I just want to point out that sections of corrugated metal were observed in and around the building. It's unknown whether or not these came loose due to wind, but it does speak to the fact that this is not a controlled space. People can get in and out of the building. And as we talk about the definitions for a dangerous building, that becomes a little bit more germane with respect to public safety. So our preliminary results here, first of all, the 1997 Uniform Code for the abatement of dangerous buildings provides us with our definitions for what is considered to be a dangerous building. There's 18 separate criteria that define a dangerous building, and Section 302 of that code is the pertinent section. And I've snipped the language there, but for the purpose of this code, any building or structure which has any or all of the conditions or defects hereinafter described shall be deemed to be a dangerous building, provided that such conditions or defects exist to the extent that life, health, property, or safety of the public or its occupants are in danger. So with that in mind, this is where we look for the different criteria that could make this building be considered to be dangerous. We found 3 different criteria that we felt, based on our structural analysis, met the criteria for a dangerous building. Item 3 out of Section 302 states that whenever the stress in any material, member, or portion thereof, due to all dead and live loads, is more than 1 1/2 times the working stress or stresses allowed in the building code for new buildings of similar structure, purpose, or location. Based on our analysis for dead and a live load of 20 pounds per square foot, which is a very light live load for this type of structure, both the main building steel channels that support the mezzanines are overstressed, and the demand capacity ratio is greater than 1 1/2. In fact, the channels have a demand capacity ratio of 27, which means that they are 2,700% beyond their capacity support code required loads. The east building wood mezzanine 2x joists are also overstressed, and those demand capacity ratios exceed 1.5. We also found portions of the building that met criteria 6, that states whenever any portion of the building or any member, appurtenance, or ornamentation on the exterior thereof is not of sufficient strength or stability, or is not so anchored, attached, or fastened in place so as to be capable of resisting a wind pressure of 1/2 of that specified in the building code for new buildings of similar structure, purpose, or location without exceeding the working stress permitted in the building code for such buildings. In layman's terms, what we're saying here is that the the structure has to be able to resist, not exceeding a working stress of 1.5 times for wind load, basically. What we found, number one, as we've already stated, that the omni columns, because of the lack of positive connection, don't have adequate capacity to resist uplift. Furthermore, because of the lack of flange bracing, the length of the unbraced length of the columns, the west building steel columns are overstressed for wind, as are the main building steel columns for wind loads also. And finally, item number 7, which we found that we had portions of the building that this criteria. Item 7 states that whenever any portion thereof was racked, warped, buckled, or severed to such an extent that walls or other structural portions have material less resistance to winds or earthquakes than is required in the case of similar new construction. As I mentioned earlier, we observed the load-bearing stud wall that appeared to be bowed out of plane. Because that's supporting the mezzanine structure, which is tied into the walls, it's likely that that can pick up lateral loads. It's going to be loaded with lateral loads, and because it's bowing out of plane, it doesn't have the capacity that we did expect it to have to resist those loads. So those are the 3 items that we found that, in our opinion, would define this building as a dangerous building. And that is that's my presentation, and I will be happy to take any questions which I may have.
Thank you very much for the presentation. Board, any questions? Yes, sir.
Would it be reasonable that the building could be repaired, brought into code, or, start over kind of situation for the structure?
Sure. Is it, the question is it reasonable? Reasonableness is for a bit in the eye of the beholder. As far as can it be repaired or brought to code? Yes. I mean, there certainly could be repairs that could be affected out there to strengthen deficient elements and repair. Our scope is not included in putting together a scope of those repairs at this point. That could be used to get an estimate of that cost. But is it possible to repair the building? Yes.
All right, thank you.
Sure.
Yes, one or two, just, I guess it's kind of silly and obvious questions, but with the chair's permission. The building is, in your opinion, structurally unsound.
That's correct. It doesn't meet the requirements of the building code.
But there's a difference between meeting the requirements of the building code versus being unsound. I mean, a lot of structures might not comply strictly with the uniform code, but might still be structurally sound. I mean, is it currently in its current state structurally unsound?
Is there, if you're asking, is there an immediate an imminent threat to life safety? No, we didn't see evidence of that. However, the minimum requirements for a building are set forth in the building code. It doesn't meet the requirements for the building. If you have a high wind event or something like that, that we're required, at least from an engineering standpoint, to consider a building safe, it doesn't meet those
Okay,
requirements.
so a high wind event or just the passage of time might cause walls to buckle, panels of corrugated steel to fly off, things like that.
That's correct.
Okay, the building, I'm assuming that this is implicit in your report or in your comments, but it is currently unsafe and unfit for human occupancy.
That is correct.
And it is in violation of a number of different uniform code requirements.
That's correct.
And it is a public nuisance. Would you believe it to be a public nuisance?
Well, I would say that is beyond my expertise as a structural engineer. All I can tell you is, does it meet, the structural requirements. There's, public nuisance is not my domain.
Well, that's a legal question.
Sure.
Okay. Good, thank you.
Sure.
That's fine. All right, thank you.
All right, thank you.
I'm going to introduce Ken Bell, our Deputy Fire Marshal.
Good evening, Kenneth Bell, Deputy Fire Marshal, City of Rowlett. Real quick, the representative owner's rep does want to speak. I'm going to have to retrieve her once her time, just to let you know. The other occupants do require constant supervision. I've had 2 opportunities to inspect this building. Both cases have found 2 independent, intentionally set fires that have resulted, one just in the last 2 weeks, where we had to take someone into custody. The first fire was set at some point, and nobody even reported it. This was in a rafter area that was depicted in several photographs here. It was in the mezzanine area and on the structural side of the building. The means of egress for this building are manifestly unsafe. During our inspection, we noted the basic nuisances, and I call them basic because I see them in a lot of buildings, but those are ones that are usually having to be remediated. Signs of drugs, graffiti, where panels have been, we found needles, blades, that sort of thing inside of them. The side panels and other items that we would typically find to secure a building, or obviously where I would secure something, somebody would come along. Obviously, in the second inspection that we made just about 2 weeks ago, everything was different. There had been new products introduced into the building, and I believe a couch had been introduced into the building. I don't know where that came from. But had that couch been set on fire 2 weeks ago, we wouldn't even be having this discussion tonight. Bottom line is that the building does have some security issues. It is a nuisance to the public, and it is an attractive nuisance if nothing else. It's the only way we found the fire the second round was the train, DART called it in. We still found the person involved as a juvenile still inside the building. So had she not been found, we might be having another discussion tonight. So it's the kind of condition that we're dealing with, and I'd leave any questions for you.
All right, thank you. Any questions? David? I know you're going to have one.
I guess for the record, at the last meeting, the board ordered the structure to be secured by the city, and I understand that we've made attempts to lock it up and prevent vagrants, other people from getting access. But that's been a problem, hasn't it?
Yes, sir. As a door, I've locked it myself, but it means nothing if you can peel a piece of the wall away and make entry.
Okay, so some of the photographs that we saw earlier, I don't know if the board noticed, but there was one photograph that had a photo of the back door that was wide open.
And that is part of the issue. I mean, like my first inspection, and I was the last one to leave. I helped secure it with chain and lock, only to find it last week or 2 weeks ago in disarray.
Who would be doing that?
Unknown. It's obviously well occupied by vagrants. Obviously, I have fire setters, juveniles that are inside this building. So I do know that person made entry.
Can I ask a question of the structural engineer based on the fire?
Any more questions for?
Yeah. So based on our discussions about the fires that are being set, are the stresses to the members such that a singular or multiple beam or column being damaged by fire, would that be catastrophic?
I would say that it could be. There's no, first of all, I would just say from a fire standpoint, it's a steel frame structure overall. There's no fireproofing present in there. These structures tend to be not particularly redundant because they're, you have a main frame and you have very light framing. There's not a lot of ability for things to redistribute. The same token is not a particularly heavily loaded structure, but if you did have a fire, you wouldn't expect to have a 1 hour rating or anything like that, and you would probably lose structural integrity pretty quickly.
Thank you.
Any other questions? Anything else?
I have nothing else unless the board has any further questions for staff or a consultant.
Because we don't, at this point in time, I guess we're going to go out and get the family.
I have to say, I'm pretty actually here in person.
I think that's the part that I find the most amazing.
It's impressive. I've had some people say, "Hey,
Yeah. That's a motion working on it.
I'm sorry?
It's a motion working.
Yeah, yeah. Yes, sir. Getting something about it.
So were you two, after a while, you'd be giving us back, again, I don't have them with me, what the recommendations were from before, correct?
Yes, they changed slightly because of the previous order that's already been made, so they've been condensed down to two or a combination of the two together that I will go back over with you once the hearing's been closed and everybody is.
Okay, great. I'll make sure.
Yes, sir.
Thanks.
Thank you for waiting. This is Donald Martin, her Hazel Martin's sole heir.
You want me to sit here?
My father.
Are you sure you're in this chair?
Thank you.
That's it.
You're welcome.
And I'm going to shut this down so we don't have any interruptions by phone. And I apologize, I don't recall what question was asked or where. Mr. Berman, did you have a question for me?
Yeah, do you have any information on the status of the guardianship proceeding?
Well, I wish I could say that I do. I don't. But what I do know is that everyone is willing to work in accordance and together regarding this issue.
Okay, that would be Mr. Coddington.
Mr. Coddington, to my knowledge, yes, Mr. Coddington is willing, all the sisters are willing,
Okay.
to the best of my
Okay.
knowledge.
Is Chris Harden still representing Don Martin?
Yes.
Okay, because I haven't heard from Chris Harden. It's been like a year before.
Okay,
Would you be willing to meet over here tomorrow morning at City Hall
absolutely.
with staff and I so that we can talk about it
Yes.
at 9:30 here at City Hall? Unless you guys want to do it over at DSP?
City Hall is on.
Absolutely.
Okay, all right. So, I I will expect to see you here tomorrow morning at 9:30. You don't need to bring Don or Hazel.
Okay.
Thank you for coming. I think for our purposes tonight, I'm still going to make a recommendation to the board that we enter order. But what we are necessarily required to impose certain deadlines, and if the property owner fails to comply with the requirements, there's no penalty or sanction. It just gives the city the option to proceed and do the work if the city chooses to do that. Does that make sense?
I understand. Yes.
So that the recommendation from staff tonight is going to be that the board require that the property be remediated or repaired, and that a building permit, this is staff's recommendation, that a permit be requested within 30 days. But if you don't ask for a permit within 30 days, it doesn't mean that anybody's going to get arrested or fined, or that the city is automatically going to take over and assume ownership of the property, because it simply doesn't work that way. It just simply gives staff the option to then proceed.
I see.
And you all understand that the property has been in this condition for an awful long time. I don't know if you were in the room a minute ago when it was discussed, but we found a 13-year-old girl from the middle school around the corner in the building, trying to burn it down about a week, 2 weeks ago,
Oh, mercy.
because she was hearing voices. We kick vagrants out of there on a regular basis,
Mhm.
and given the condition of the structure, it's not just that we have vagrants and that problem. I mean, it's a public nuisance and an eyesore, and we've been working on this for years, and haven't, it's not gotten better. So, can you meet us here tomorrow morning at 9:30?
Yes, sir,
Does that
absolutely.
make sense? Yeah.
Yes.
I'm looking at Community Services Director, and, okay, very good, thank you, Paul,
All right.
for coming.
Absolutely. Thank you so much for hearing me and allowing me to interrupt and go out of order. I appreciate it very much.
Absolutely, thank you.
Thank you.
Is there anyone else here from the family to speak?
No, sir.
That being the case, of course, we need to, this is a public hearing, so we need to open the public hearing. I have one comment card from a Thomas Keene. I get you to come up to the front and give us your name and of course your address, please.
Good evening, my name is Tom Keene, and my address is 555 Republic Drive, Suite 325, Plano, Texas. I'm here on behalf of people who've been trying to purchase this building. We've had the same problem the city has in getting any kind of agreement or order from the court. I know that the city filed a plea and intervention in the guardianship that's currently pending. The person that owns this property has apparently not been adjudicated incompetent, but there have been 2 reports turned into the court that say that she is incompetent. I don't know what else Mr. Berman may have done, but I know that he filed a plea and intervention and asked that either the property be removed from the estate or that the estate be ordered to secure the property and take care of it. To my knowledge, there's no order that's been entered by the probate court on that plea and intervention or on the request of the city. So, number one, I question whether or not the Board of Adjustment has the right to move forward in the face of the guardianship that's currently pending, trying to adjudicate the property owner as incompetent. There has been an attorney ad litem appointed representing her. I have not heard from him, although I have called. He should be the person that would be taking some action, and I don't know why he hasn't. David may have light to shed on that.
I've got a lot of information about that, but I think I will say this, that we did file, I think it's probably beyond the scope of the public hearing, but, and with the chair's permission, we can address that issue.
Absolutely, I'm intrigued.
So we worked with the attorneys who, and there are multiple attorneys, who are representing different parties to the guardianship proceeding. It is not within the scope of the Board of Adjustment's jurisdiction to adjudicate anybody as being non-compos mentis or unable to handle their affairs. That's not what this hearing is about. The purpose of this hearing is to proceed with an independent and relatively impartial tribunal to adjudicate the condition of the property, to determine whether or not it is substandard, unfit for human occupancy, an unsafe structure, a public nuisance, and then what could be done with it. We have tried to work out agreements with the lawyers who represent parties to the estate, and we thought we had twice. formal agreements that would have removed it from the estate. And those agreements and the processes that had been initiated were just simply dropped, and the lawyers, all of the attorneys just fell silent. And there has been no motion at all. And in fact, in one and only single hearing that has ever been held in that court, the judge said, and that was quite some time ago, no, Mr. Berman, you have the option to proceed with your code enforcement processes, and this is our last resort.
So your relief has not been granted in the plea in intervention. And the problem with due process is the property owner has the right to be here, but the property owner has possibly an official representative in the attorney ad litem appointed to represent that person's interest. And that attorney ad litem is not here, and there still has been no declaration on whether or not the person is competent, but that guardianship is pending. And that's the problem with due process tonight.
Well, actually, due process requires notice and a meaningful opportunity to be heard. I cannot arrest Chris Everett and drag him down here against his will, but I can give him notice by certified mail and regular mail, which we've done. If he chooses not to be here, then he foregoes his due process rights for himself and his client, as well as all of the other dozen or so people that we have notified of the proceeding last month and the proceeding tonight. So if your concern is due process, I'm not quite sure you have standing to say that. However, you are incorrect in your analysis.
The meaningful opportunity to comment is the problem here, and there's been no adjudication in that court, but you are aware that there have been reports filed saying that the property owner is incompetent. But we can leave that for the courts. Beyond that, I heard tonight that although this structure has been open, I think it was ordered to be secured by city staff, and apparently nobody put a construction fence around it or tried to do anything like that. They tried to lock the doors. There's metal sheeting on this building that is not well attached, and I don't think anybody has any debate about that. It's not structural, it's not what's holding the building up, and it's not part of the analysis. If that's going to continue, I mean, it needs to be removed probably and replaced, or the building needs to be rebuilt. Now, as to the structural rigidity and resilience of this building, it's got a great foundation, a very, very thick foundation, unusually thick foundation. It's got steel beams holding it up. I don't think the structural engineer would disagree that those parts of this building are still intact, and although there may be some bracing that needs to be put on some of the cross members, that this building is essentially structurally sound. Yes, it needs to be secured from outside penetration. It needs to be kept from homeless people wandering in, certainly people starting fires. That can be accomplished. Accomplished with a construction fence. I don't know why that wasn't done. But we are here because we want to preserve that building and put it into use, not have a vacant building out there. Yeah, we have to reach an agreement with the same people that you guys have been trying to reach an agreement with. There is already a court proceeding that would allow that to happen. And I don't know what happened with Mr. Berman, but his relief that he has requested has not been granted by that court. So we would ask that the board not take this action tonight. I was relieved to hear that it's only a repair order and that a permit be pulled, but I don't know that that's what the board is going to do. I only heard that that was one option. Again, it's going to have to happen really fast because we have the court proceeding that is still currently pending, and it's going to depend on the court schedule as to whether or not the court's going to be able to enter an order. And I sympathize with Mr. Berman's plight. He did file a plea of intervention, which I think is great, but there hasn't been a hearing on that plea yet, so I think this is still premature. We would urge the board not to move forward to order a demolition of this property and to try and preserve it. Again, a construction fence can be put around it to keep the homeless people out of this property. It can be secured.
Thank you.
Thank you.
And just so I'm clear, I don't believe there's actually a order for demolition here anyway. There's not an order for demolition here anyway for us to consider.
Don't need an order. That's one of the options that you have seen is consider demolition. Let me reiterate again, I think, Maria, you correct me if I'm wrong, but I think staff's recommendation, and given the length of time this property is in the city, last year we had a representative lawyer who was one of the attorneys with the firm that represents Dunbar asking for additional time. I think staff's recommendation this evening is not to require the property to be demolished, but to give the property owner, and impose an order that gives the property owner 30 days to submit a building permit to either, number one, repair or remediate the structure, or number two, demolish the structure, either or. But it's, for example, if you issue an order requiring they apply for building permits to repair the structure and they submit a demo permit application, then we kind of be stuck. So the request from staff is to enter an order that imposes a time frame within which some either repair or demo permit application should be submitted, and then to impose an order that requires that the demolition or the repair, either or, be completed within a certain time frame, like 90 days to 120 days or whatever it is. But if no permit application is submitted for either repair or demolition within the 30-day time frame, then you authorize the city to assume that responsibility. If the city does assume the responsibility, it's going to be the city's decision, staff and probably council, to consider whether or not the property should be repaired or should be demolished. It's going to be done at public expense. If we do this, and trust me, I tell you that is our absolute last resort. But if the city does it, then we would necessarily file statements of expenses with the county clerk's office to secure our costs, and we file a lien against the property to hopefully recover the amount that we spent on doing the repair or the demolition. My understanding is that Mr. Keen's client wants to preserve the structure as it is, and that if you repair it so that it can be occupied in the future with a similar or identical elevation. I recognize that the property owners needs, the family's desire to get this thing taken care of. We're going on about 3 years now, maybe 4. And we're trying to be as accommodating as possible to everybody. But it seems to me like the more we attempt to accommodate, the only result is more delay. In the probate action, we had an agreement, and the attorney representing Don Martin, the applicant, the plaintiff in that case, had begun preparing documents. We had a whole system, and it required the appointment of a substitute temporary trustee and required consent from a bunch of people. The documents were halfway done, and then all of a sudden, this appeared. So, contest has been filed and withdrawn, and the contest in different areas of the state of the So we're not getting anywhere with this, and so our absolute last resort is for the city to step up and do something at public expense. But we need an order from you guys, the city, to do that. My recommendation to staff, by the way, is if we have the order from the board that requires repair or demo permit within 30 days, and then if no permit application is submitted, the city has a 3-step interview. My recommendation to staff is to take this to council in executive session, and with that order, we can get direction from the access to do. That doesn't mean that we're going to repair it or demolish it within 10 days or 30 days, or that we're going to do anything at all. It just gives us the option that we absolutely have to take what we're due.
So David, tell me, provide the order of fixing here, or at least the request. If the owners show up tomorrow and indeed work something out, have we made some kind of ruling either way this evening? How does that impact? I mean, still would be one that they could.
Oh, that does not mean that all is lost. If we can work something out with the owners tomorrow, But if we don't have it, I will say this, we can meet with staff, hopefully will be in this morning, tomorrow morning, but they could not agree to anything absent an agreement with the attorneys to represent the parties in the probate action. The only way that this property can lawfully be conveyed to anyone is through a court order that authorizes the conveyance. And that court order, getting there, is a difficult process. Trust me when I tell you, it is not simple and straightforward. And so we can at least lay the foundation to go through that process and get the lawyers to finally finish off the paperwork and sign off on it, and then have a hearing set, which would be wonderful. But if that doesn't happen, then we at least have the order from you guys to back us up. Because we were at that point 2 years ago, literally 2 years ago, maybe 2.5. And it's not that I don't trust the other lawyers, it's that I want to be able to cut the deck. And I have absolutely no key of any. So.
Well, quickly, let me just go ahead and right quick. I don't have any other cards as far as to speak on the public hearing itself. Is there anyone else who would like to speak on the public hearing? Not being seen, I will close the public hearing. So you move on. It's where you gonna give us your next.
Now it's time for the board to entertain an order. As Mr. Berman indicated, we're recommending that you require the owner of the property to repair, remediate, and or demolish the structure and obtain a permit within 30 days and then impose a timeline to have those things complete, depending on what they choose to do.
That's the only option we have now.
It's not the only option you have. If you wanted to break out those options, you do have the option of requiring the owner to just repair or remediate the structure, bringing it into minimum compliance, also imposing some kind of deadline for them to secure a permit, that separately, or also separately requiring the structure to be demolished and obtaining a permit within some, time frame, or what I had previously stated, a combination of both, so that it leaves options open for the owners to make their own decision.
All right, thank you. Any questions for staff? I would expect a comment to think that, I think that we all think in the best interest of the city. We want something done with the property, one way or the other. As a long-term resident as I am, that thing's been as beautiful and as an eyesore for many, many, many years. I think it's been described to this board is that something has got to be done. I'm very grateful for Ms. Martin coming in and Mr. Martin taking the time today to come in and finally to at least address that. And hopefully tomorrow you will show up, and the end game being here, of course, that the resolution to be resolved. That being said, of course, it's still something that needs to be done on behalf of this board. I am more so inclined to, in my own opinion anyway, to think that we should move forward with some kind of a suggestion that the city be given the opportunity, providing that the owners cannot come to terms. I personally would love to have something done with the building. I don't know what your plans are, but we would love to see something go in there. It's a perfect looking building for us, but then it's just unstable. But from my perspective, I think that this board should definitely consider the options about giving the city. It's been many years, been long-standing for us to do something with it. We gave it the benefit last month to hear from the city and hear from a structural engineer, and thank you for that. I think we are compelled to at least put it out there, the timelines that need to be done, so that we can give the city at least a little bit more of a push point that you guys can move off dead center. It sounds like it's been going for a very, very long time. So that being said, again, just my own personal opinion. Or anything else? Comment?
Yes.
Yes.
I believe in our order, we ought to specify that the building needs to be secured, a fence or something to keep people out. Since the building is basically safe.
We did
The
order
city
that last
can,
month.
we can,
We did order that last month, and it was secured again, and not by the means of a fence all the way around it, but we did, of course, request that the building be secured.
but apparently the order has not been effective, I'll put it that way, the way it's been secured. Maybe secure it by a fence or something around it.
Well, again, I think then the fact that the order be given, that allows the city up to 30 days to give them that option to do something with it. I think that's been suggested here by the fire marshal, that it was secured, and within a couple of weeks, it was still broken into. So I think that would, whether you did it with a fence or not, I think until that building is secure, being locked down, which again,
Construction fence only slows them down a little bit anyway.
it's my opinion.
Push them over.
No other questions, I will entertain a motion.
So, Mr. Chair, I would like to make a motion to require the owner of the property to repair or remediate the structure, bring it into a minimum compliance, imposing a deadline of 60 days to submit building permits and a schedule for completing the work. And the permits or work are not done within the time frame allowing the city to enter the property and do the work.
Do I hear a second? Any other discussion? We'll make a motion. Go ahead and call the vote. And the motion carries. That being said, we are done with our meeting and we are adjourned.